Better Markets is actually more pro-free market than the biggest too big to fail banks on Wall Street, because it is for a free market where no bank is too big, too important, too complex, or too interconnected to fail. And most importantly, a free market where no bank or banker is too big to jail or be punished just like anyone else who breaks the law. That is why Better Markets filed this lawsuit today against the Department of Justice and Attorney General Eric Holder. Eric Holder personally negotiated this deal, along with other senior political appointees at the Department of Justice, with the CEO of Chase, Jamie Dimon. And the contract they entered with absolutely no oversight or accountability, no involvement of any court to review or approve the settlement. How much did JP Chase's clients, customers, counterparties, and investors and others lose as a result of the fraudulent conduct? Was it $100 billion? Was it $200 billion? Was it more? No one knows. How about the profits? How much revenue, profits, and other benefits did JP Chase receive as a result of its fraudulent conduct? What was the scope and thoroughness of the investigation that provided DOJ, the Department of Justice, with an adequate basis to determine that $13 billion was the right amount to punish and deter the years of illegal conduct that this settlement supposedly addressed? That is why we have sued the Department of Justice and Attorney General Eric Holder. We have sued them for violations of the Constitution, the separation of powers, the failure of checks and balances. Our complaint has 7 counts. We seek to enjoin and stop the $13 billion settlement, and we seek an order from the court that requires the Department of Justice to submit any agreement with these historic facts and circumstances to a federal court for review and approval.
I suspect JP Morgan is going to argue that this was for actions taken by institutions that it was asked to purchase, etc. Is this something that you might do in the Bank of America for its countrywide?
JP Chase, in particular its CEO Jamie Dimon, loves to talk about how they shouldered the burdens of the financial crisis by taking Bear Stearns and WAMU and doing all these things as great public servants for the American people to save America at the time. They forget to mention all the time that they bought those 2 organizations for almost nothing and have profited enormously over time. And as is standard and usual throughout history, and as Jamie Dimon knows well from his deal-making years, when you get the upside of an acquisition, you get the liabilities too. But let's focus on something else here. The $2 billion penalty of the $13 billion is solely due to the illegal conduct of JP Chase, not WAMU, not Bear Stearns, nothing else. And indeed, the Department of Justice, according to certain media reports, gave JP Chase a break for the illegal conduct due to the 2 companies they acquired.
Can you explain why Better Markets believes it has standing here and what harm you're going to allege that Better Markets has suffered?
Better Markets, as we'll show and as we've pled in the complaint, has concrete and demonstrable injury across a variety of issues, not the least of which the organization exists for the sole and unique purpose of promoting transparency, accountability, and oversight in the financial markets and in connection with the conduct of regulators and prosecutors like the Department of Justice. We pursue the public interest through rulemaking, through research, through public advocacy, and importantly, through litigation and legal matters. And it will be hotly contested, but I believe we have a solid foundation to prove and demonstrate concrete and demonstrable harm that give us ample standing to assert both the constitutional claims and the statutory claims.
Hi, Lauren Windsor with the Young Turks with the Undercurrent. Given the scope of the fraud, what would you consider to be a fair settlement?
The problem is that no one, except maybe Jamie Dimon and Eric Holder, but no one else could answer that question. This entire contract, if you look at it, it appears to be very carefully crafted to conceal all the meaningful facts here. The consequence of that is not only that you can't figure out the illegal conduct done by JP Chase, but it also prevents everybody from evaluating the conduct of the Department of Justice and Eric Holder. The Attorney General himself testified last year to a double standard in this country. He says, as to the biggest too big to fail banks on Wall Street, we consider what he called collateral consequences because they're so big that if they fail, they take down the financial system and they require taxpayer bailouts. And the Attorney General personally in the Department of Justice, as documented by 60 Minutes, Frontline, and the rest of the media, has come under a mountain of criticism for that testimony last year and for their miserable track record here. So they want to come out, and they did here, bragging that we're tough on Wall Street. We bagged the big one. We got $13 billion. We're not going to tell you anything about it.
Senator Warren spoke to this last week during a regulatory committee hearing about adequate risk deterrence.
JP Morgan spent nearly $17 billion to settle claims with the federal government. Claims relating to its sale of fraudulent mortgage-backed securities, its illegal foreclosure practices like robo-signing, its manipulation of energy markets in California and the Midwest, and its handling of the disastrous London whale trade. And at the end of the year, JP Morgan gave its CEO, Jamie Dimon, a 75% raise, bringing his total compensation to $20 million. Now, you might think that presiding over activities that resulted in $17 billion in payouts for illegal conduct would hurt your case for a fat pay bump. But according to the New York Times, members of the JP Morgan Board of Directors thought that Jamie Dimon earned the raise, in part, and I'm quoting here, by acting as chief negotiator as JP Morgan worked out a string of banner government settlements. I think this raises questions about whether our enforcement strategy is working or whether it's actually so bad that we're making it more likely for big banks to break the law. Neil Weinberg, the editor-in-chief of the American Banker magazine, said that in the current environment, quote, bank executives would be crazy to hold back. If they get caught, they can pay their way out of the problem with shareholders' money. And if their misdeeds pay off as expected, the profits will goose their pay. I'll add, even if they do get caught, the executives might still get a raise. So here's my question. Does anyone on this panel seriously think that the government's current enforcement system for financial crimes is actually working in the sense of deterring future law-breaking?
Do they have the tools and they're just reluctant to use them, or do we need to have greater regulation?
The Department of Justice has an ample set of tools to enforce the law on Wall Street. What it has lacked, indefensibly, is the will. So I saw the hearing last week, and I thought Senator Warren's questions were right on point. What we need here is the prosecutorial will, the commitment of resources, and the guts to take on the rich, powerful, and well-connected on Wall Street with as much zeal as they're willing to go after lawbreakers on Main Street.
Undercurrent, under the surface.